Fighting this timeline with snark. Every soul welcome but no recorders. Baptized by laughter in the dark. We stand tall, scorning fake orders. In the church of law we rise. With chaos and shenanigans bright. Sharpening sarcasm our rise. Together we light up the night.
Welcome, everyone. This is the Suzanne Morphew DA Disgrace document. She is recommended to get disbarred. I do want to do a little bit of a warning on this particular section of this disciplinary order. This does involve the unaliving of a 10-month-old child due to CA. I never want anyone to sacrifice their mental health or anything like that. So I do want to do a warning just in case this is something that, you really can't handle. I completely understand. Child cases are very, very hard for me, and I know they're hard for a lot of us. So I don't want anyone to ever, put their mental health in jeopardy because they want to watch a video. That's why I'm going to try to keep this particular, section kind of to itself. This might be a shorter stream, but again, I do want to get this information out there. I think of all the things that she did on the Morphew case, this particular misconduct is the worst. I think the fact that she robbed the 10-month-old child of ever getting justice because she so bungled the case is reprehensible, is outrageous, is beyond terrible. And welcome, Jen Thunder. Thank you so much. And I love Squid. We are going to be tag teaming the Sarah Boone case, which reminds me, instead of nightly newsy news, we will have another very Sarah special where we will go over this motions hearing, probably with an adult beverage. Her annoying squeaky lawyer is about to make me have a stupid aneurysm. And that was just the last time he spoke. So we will get into this again. Protect your mental health. This is about a child. This is not a great thing to have to talk about, but I do want to expose what this ridiculous DA did. Yes, I don't name her. I don't give her any credit other than to call her the DA. In this paperwork or in this disciplinary recommendation, she is called the respondent. So I will try to, say DA instead of respondent, but I might mix up a few times. So I did want to kind of explain that to you. But this is the Jacob and Crawford cases, findings of fact. Prosecution of Jacobs and Crawford. On May 22, 2023, the DA brought a case in Fremont County against William Henry Jacobs arising from the death of a 10-month-old child. Now, all of these footnotes are stipulated facts. If I find a footnote that is not a stipulated fact, I will let you guys know. On June 2nd, 2023, the DA charged Brooke Crawford, the mother of the child, as a co-defendant. Charges stemmed from an incident that occurred while the child was in Jacobs' care. The DA formally charged Jacobs with first-degree murder and 2 counts of felony CA, resulting in the death of a 10-month-old child. He was also charged with misdemeanor animal cruelty. Crawford was charged with felony CA, resulting in serious bodily injury, misdemeanor CA, and misdemeanor animal cruelty. The DA then went on to have an interview with local media. On July 12th, 2023, the DA appeared in court in the Jacobs and Crawford matters. Investigative reporter Sean Rice and photojournalist Peter Miller, both with Colorado Springs KRDO News Channel 13 Investigates, were also present in the court that day. Rice testified that he and Miller traveled to the courthouse that day, hoping to speak with the DA, who had not often responded to his requests for statements or interviews. He had unsuccessfully tried to interview the DA almost a dozen times, he said. After the hearing, Rice and Miller caught up with the DA in the hallway adjacent to the courtroom. The camera was rolling, and Rice had a mic in his hand, and he asked her for an interview while Miller filmed the interaction. The respondent testified that she had a quote-unquote history with Rice. She believed that Rice had written several unfavorable stories about her, many of which she felt were incorrect and geared toward the sensational rather than the factual. She was often irritated that Rice, whom she perceived as lacking an understanding of the criminal justice system, asked her loaded questions but failed to include her answers in stories. She also wanted to defend her office, but worried that if she did so, Rice's coverage would become more hostile. So she usually did not go out of her way to talk to Rice. Way to make it all about yourself. You are supposed to be the voice of this 10-year-old child. You are supposed to be the voice of all of us people who cry out for justice. You are not you when you're a DA. You are supposed to be speaking for us. You are supposed to be speaking for we the people. And we the people are pissed off that a child lost his life. But you are more worried that you're getting negative coverage because you are a bumbling thunder cow. And I'm trying to keep this clean, but I might start cursing here. So I will try to keep this as relatively full of moisms and false curses, but one might slip out. Fair warning. When Rice approached her in the hallway, she recalled a media training presented by Dan Rubenstein at the Colorado District's Attorney Council, or CDAC, September 2022 conference. She remembered Rubenstein encouraging CDAC's members to engage with media and to correct inaccuracy. Oh, no worries. Thank you for joining us. And, we appreciate Replay Crew too. But I did kind of want to quarantine this section. So I'm glad that people are willing to do that with me. All righty. Okay. Which can snowball if unchecked. So these inaccuracies, they want to be able to correct them because they don't want reporters going on, crazy conspiracy theories. She also recalled specific recommendations that district attorneys should engage and build relationships with journalists who write negative stories so that the district attorney can become trusted sources for accurate reporting. As a result, the DA agreed to talk to Rice, and she invited him and Miller to her office. Save for a few shots of the DA walking through the courthouse hallway, all portions of their recorded conversation were filmed in her office. She was seated behind her desk, and her attention was often focused either across her desk at Rice or on her computer monitor. Rice's sole interview of the DA was filmed that day. Seated in the respondent's office, or in the DA's office, Rice and the DA spoke off camera, off the record, for approximately 1 hour. During that time, Miller was seated in a chair in the corner of the DA's office. Rice and the DA discussed the Jacobs case, judges, bond decision, county commissioners, and the DA's budget, among other topics. After the hour-long conversation, Rice testified he noted a looming deadline to file a report for that evening's broadcast and asked the DA if she would go on the record for an interview. The DA consented. Miller left to fetch his tripod. He was away from the office for about 10 minutes. During that time, the DA testified she told Rice that she could answer questions about open or sealed case, but her comments about those cases must be off record. The DA said she was issued this warning when the CDAC was training her. And from that training, she said she understood that she could alternate between on and off record conversations by instructing the reporter in advance what she could and could not discuss. According to the DA, Rice agreed to her parameters. She expected that Rice would relay the agreement to Miller, who would also comply. The DA testified that she had no reason to believe that KRDO would violate the understanding, and she believed that Rice would abide by the professional standards she outlined based on her initial instruction. But Rice reported no such exchange. Instead, he testified that during Miller's absence, The DA did not state she wished to be off the record. I'm gonna believe Miller before I believe this particular DA. According to Rice, Miller turned up and set up the video camera across from the DA at an angle facing her desk. The large video camera, Rice estimated being several feet long, was in plain sight, with an outward facing red light visible to the person being recorded. Miller handed the DA a wireless microphone, which she clipped onto her jacket lapel. The microphone battery pack was positioned visibly on the respondent's desk. She didn't even put the little, battery pack in her pocket. What an amateur. Ma'am, as you are probably going to be without a legal license, I'm going to tell you that if you would like to come over to YouTube, you're going to need really good audio. Just a heads up. Rice interpreted the DA's actions as a signal that she was prepared to speak on the record, and he said thereafter she never explicitly asked to speak off the record, but the respondent or the DA contended she was not aware of the camera's red light and not told that the camera was rolling. Ma'am, seriously. Okay, Jan. All right. I did not see it. I am legally blind. Really? During the recorded portion of the interview, aka the raw video, which lasted 29 minutes and 42 seconds, Miller started and stopped the video at various points. Rice said that no portion of the interview was removed or edited. He did explain, however, that the interview comprised 4 clips, which he transferred from Miller's SD card to his own computer. Rice then knitted the 4 recordings together into a single chronological raw video using Adobe software program. Can he come and edit my videos? I'm just asking for a friend. The raw video begins mid-sentence with the DA commenting on Jacob's quote-unquote violent and awful past, which included fondling his mother. Gee blitz. Quote, what kid fondles their mom? Respondent asked rhetorically. The DA also testified she made the comment when Rice himself brought up the information. The discussion transitioned into whether Rice could gain access to Jacob's juvenile records. While looking at her reporter, the DA testified that she was reading from Jacob's juvenile files, and she observed that Jacob committed juvenile offenses in 2017, followed by, quote, so if you do the math, before trailing off. The DA's comments seemed to imply that Jacobs was quite young when he committed this offense. She also advised Rice to visit the county clerk's office for Jacob's file, opining that certain juvenile records were publicly available by statute. First of all, this is incredibly damaging and, prejudicial instead of probative. She should never be looking up someone's juvenile files and giving them to a reporter, regardless of if she thinks she's on camera or not. Again, these are things that made it impossible to prosecute these 2 human people that possibly, allegedly, since they have never been found guilty, unalived a baby. Now, what level of cranial rectitis, how far into your own, colon are you, ma'am? Are you going to have to pull a Lemmy-Winks and actually bring your head out of your neck? Because I am so beyond irritated right now. She knows this stuff. This is not like day one, lawyering. I am not sure, since it looked like some maybe SA elements, that they would keep that on. I am not quite sure. The DA then commented about Crawford's motives and character. The respondent concurred with various social media commenters who questioned how Crawford could leave her baby with someone she allegedly just met. The DA remarked that she would not let anyone meet her children when she was raising them, and she editorialized that if someone had touched her child, she would have, quote, went and unalived them, unquote. She added laughingly, I have a fire pit, I'm a prosecutor, I know where to hide the evidence. Ma'am, this is probably not the best line of questioning for you. Also, now we need to check your fire pit. Around minute 5:10, the DA remarked that Jacobs was released from custody, a fact that Rice appeared not to know. And she predicted, quote, he's going to be gone. He knows what's going on. He's no dummy to this process and what's happening, what he did, end quote. 26. At respondent's request, Tito Viole was qualified as an expert in forensic video analyst. Violte observed that an early portion of raw video contains two disjointed frames, one right after another, and he opined that something was missing between those two still frames. On cross-examination, he conceded that the disjunction could be explained if the videographer had stopped and started the recording. Given that the DA testified she never explicitly asked to speak off record, we do not find the expert's testimony relevant. And let's see. Welcome to Raiders. I think I saw something pop up. I don't know. It's hard to watch all of this when I'm reading too, but welcome. I will tell you guys this portion of the disciplinary action does involve a baby passing away due to abuse. There's no welcome squid. There is no easy way to go through this. So I will let you guys know that this does involve the death of a child. So I don't want anyone to, disregard their mental health. Thank you so much, Toyla, sorry, and welcome Squid Raiders. But if this is a case that will, affect you negatively, I will keep this kind of cordoned in part 3, and then you can go on to the rest of the disciplinary action if you would like. I just don't want anyone to watch one of my streams and have a really bad day because of it. And I feel a very big responsibility to warn you guys. Lewis Thomas, this is the DA that tried to convict Barry Morphew. She did so much shenanigans in that case that it was dismissed without prejudice, which means should they find extra evidence, they can go back after Mr. Morphew. Now, she was involved in another case, and the case that we are currently looking on involves the unfortunate death of a 10-month-old baby boy. The DA so screwed up this case by basically unfiltered talking to the media and opening and talking about one of the defendant's juvenile cases, that this case had to be dismissed with prejudice. That means that this child, this baby boy, will never get the justice he deserves or could have gotten on earth because this woman ran her big damn mouth. Now, I have never watched or looked at the Suzanne Morphew case. I like to I'm kind of going back into cases that have a large following or have very distinct opinions and looking at them with fresh eyes. I did want to cover this because it is so incredibly rare that a DA gets a disbarment recommendation, because the way things go, they have to get a complaint, and then a committee of 2 or 3 lawyers will look at the complaint and say, okay, this amounts to nothing, or we're going to move this up to the Supreme Court and have actual hearings. Well, the astronomical, unlikeliness of a state prosecutor actually getting to the Supreme Court and then having the Supreme Court recommend you lose your legal license is almost unheard of. So I did want to start at this case or this part of the case right now. And I did not even know about this particular case that she bungled. But the people of Colorado deserve better. They absolutely do. Now, around the 7-minute mark of the raw video, Rice, so she is referred to as the respondent. I try to put in DA, but if I mix up respondent and DA, it's just a my bad. I'm trying to read. Rice asked the DA about her rocky tenure over the past several months, and she replied, quote, I don't like to bring any DA business out in the public because it's a risky thing to do. That's victim and defendants and other things that are going on that I don't think I should necessarily respond to, end quote. The DA then sidestepped Rice's questions about several cases that were dismissed in her district due to Criminal Procedure 16 violations, beginning at minute 13:05. She said, quote, "I don't think my opinion matters. I'll let the public try to figure out what they think is going on." Did you take Kamala Harris, like speech lessons? In beginning at minute 1830 of the Raw video, when Rice queried the DA about the Morphew matter, she stated, quote, "I can't comment on that. I won't. I can tell you is that it is still being worked on, but I'm not going to go any more into that." Rice pushed back, inquiring where the case might be heading. The respondent replied, "I'm not going to comment. Come on, Sean, really. Do you know how bad I want that guy? So I'm not going to comment." What a dingus. A while later, Rice and the DA segued into a frank conversation about whether the DA had avoided KRDO's interview attempts. The DA complained about her inability to defend herself. At minute 21:20, she insisted, "I can't talk about an open case, right? I'm forbidden from it. Defense can do it all day long." No, they can't. They generally have a gag order, too. This is standard procedure. And I can't say a word about an open case. She said she could not even mention a sealed case in a motion. Quote, "Sealed cases can't be talked about." And she repeated, "I can't talk about an open case. I can't talk about a sealed case," adding, "I'm going to abide by, what I have to abide by." Toward the end of the interview, at minute 25:20, DA responded to Rice's claims that he had to track her down in open court in order to secure an interview. The DA replied that she really wanted to press a button on her desk, but she told Rice, quote, "I can't do that since we're recording." Rice, confused, asked what she meant, and the DA proceeded to mention that the button, which produced a voice message intoning, "Ma'am, seriously, quote, if bullshit were money, you'd be a millionaire." This woman is trying to be a shit poster as a DA. Ma'am, do not join YouTube. We do not welcome you here. We want none of your shenanigans. You are terrible. That's not even funny. You are not even funny. You're not even hilarious. What is wrong with you? At the conclusion of the interview, Rice understood that KRDO would publish in written and videographic form contents of the entire video. In contrast, the DA testified that at the conclusion of the interview, she understood that everything she had said about open or sealed cases was off the record. In other words, she believed that nothing she said about Jacobs or Crawford would be published. As evidence, she pointed to several comments during the recording in which she reiterated that she was forbidden to speak about open or sealed cases. Then you should have kept your mouth hole shut. You know what's funny is, even as a YouTuber, even as a motor mouth who has verbal diarrhea in nervous, tension-filled situations, I can control my mouth hole. I promise you. I rarely do, but I can. So if I weren't allowed to talk about those cases, I wouldn't be BSing with a damn reporter, you giant moron. How do you even walk and chew gum, ma'am? This is dumb. You are so stupid. As to why she spoke about Jacobs and Crawford's but refused to discuss the Morphew case, she reasoned that Rice brought information to her about the Jacobs case and inquired about why he could not get records and asked for guidance in navigating the juvenile confidentiality exemptions, whereas she figured the Morphew case would not be hers to prosecute, quote, no matter what, and she didn't want to affect it by discussing it. I believe this happened in 2023. So this dropped, this particular document, let me remember, I'm on page 40. It looks like this dropped, okay, they don't have a date, but this is for Linda Stanley. She's in the 11th Judicial Circuit in Colorado. I believe this dropped fairly recently, not, I would believe in the last 2 weeks or so. My youngest, most feral, was like, "You can type without looking. That is a superpower." And I'm going to let him believe that it's a superpower for a while. I'm like, yes, I'm a mutant, super typer when I'm terrible. But this particular, I believe, case that she bungled happened just last year. So this is where the kerfuffle starts. KDRO aired two stories. Two different portions of the recorded interview aired on two separate days. One clip was broadcasted on July 12, 2023. According to Rice, the story that aired on July 12, 2023 focused on the district attorney's office criminal procedure 16 discovery violations. Now, if you guys don't know or if you just jumped in, the entire reason that the Morphew case was basically dismissed without prejudice, they had extension after extension to get their experts in. And they were supposed to get all of their experts' paperwork, their reports, and all of that stuff in at a timeline. What happened in the Morphew case is that they never had any of this stuff ready. I believe they had 16 experts that they were going to rely on. And I want you to remember that at the time that they were trying to prosecute Barry, they did not have a body. So they were going to rely heavily on these experts to kind of give the backbone of circumstantial evidence in this case. They got every single one of their experts, save one, dismissed because of improper filings. And the one that they were able to keep was severely limited because his report didn't match what he testified to. So there was a lack of leadership, there was a lack of control, there was a lack of a lot of things in the Morphew case. And she wants to blame everyone else but her, but she is supposed to be the leader that is allocating resources to these big cases since they have over terabytes, I think 1 or 2 terabytes of information that just went into the Morphew case. She basically put one guy and one assistant on it. So this case was bungled from the beginning. And it's very rare. So in response to all of their it gets worse, Louis Thomas. I would encourage you to watch the rest of this. It gets worse because the judge excused all of their experts. This DA, Miss Stanley, decided to do Oppo research and search out his ex-wife to make sure that him denying their experts was not part of a conspiracy to piss off his ex-wife, because his ex-wife has a pro Suzanne Morphew, like, find her page. They interviewed the ex-wife to make sure that the judge had never laid hands on her. The ridiculousness that has come out of this DA office makes it, I would say it makes it very unlikely that Morphew is going to get another chance or another prosecution. They have so bungled this that it could be used as reasonable doubt. Why did you, if they find the magic one-armed man and they go in and they say, yeah, we've got all this evidence, the defense is going to say, you spent X amount of dollars and X amount of money to go after someone. Why should we believe that this is absolutely more, or it's not Barry now? And thank you for being a member for 8 months. Congratulations. You're almost born. Yeah, I did not realize, like I said, I have 6 children. I have a couple cases that I try to keep up on, but keeping up on all the major cases is never going to happen. So it was really just digging into this document. I know not a lot of people are, but it is insane. This is a level of, I mean, Binger only wishes he was this corrupt. Let's be real. If Binger could have had this kind of power, he would have screwed up more cases. This is just insanity. Now, the criminal procedure 16 discovery violations, those are basically the rule under which the judge ruled that they had not disseminated things to the defense. They had not properly filed things. So all of their experts would be, taken away. So that's a little backstory if you haven't read all of the, past 40 pages. This is an 83-page motion. This chick is insane in the membrane. The respondent, so the July 12th, 2023 clip focused on the District Attorney's Office Criminal Procedure 16 discovery violations and the community fallout from the resulting discovery sanctions. The DA testified that the content of the story from July 12th was all on record. An accompanying written article titled, quote, Embattled 12th JDDA addresses allegations that she contributed to case dismissal and freed sexual predators, end quote. Well, they're just not being real nice. That is, in fact, the entire title. You know, that had to burn her biscuits when she thought I'm going to look real good, and they pull out. Yep, she let PDF files out. She was like, "Darn you, KRDO." According to the DA, Rice called her on August 1st, 2023, asking for some information about juvenile cases, and she provided him with a site for the statutory exemption to confidentiality of juvenile records. Rice did not alert her that another story featuring portions of their interview from July 12, 2023 would broadcast that night, nor did he seek her supplemental comments about the segment. The story broadcast on August 1st, 2023, interspersed with the DA's remarks, with Rice's commentary and summary of other statements the DA made to him. A news anchor, so they're going to give you the transcript. I will try to be all the people. Tonight, 13 Investigates is learning explosive new details about what led up to a baby's death inside a Cannon City motel room. The 12th Judicial District Attorney sounding off about the behavior of 21-year-old Cannon City man charged with killing the child. Investigative reporter Sean Rice is live in our newsroom to explain what the DA is revealing about the case tonight. Sean Rice. Hey, Bart, 21-year-old William Jacobs is accused of shaking and killing a baby he was watching inside Motel 6 room in May. District Attorney Linda Stanley says she feels so strongly about the case she's tapping herself as lead prosecutor in the case of a death she said was completely avoidable. Stanley. I think she saw a live-in babysitter. So this is the DA. This is the DA talking about this. I think she saw a live-in babysitter. Now, she can really just pound out the hours, right? She's got a live-in babysitter now. She doesn't have to worry about anything, right? So the fact that she is making an argument and disparaging the character of the mother of this child, regardless of how she might have or didn't, contribute to this case, is absolutely out of line. And thank you for becoming a member, Duncan, Idaho. Congratulations. Welcome to the Church of Mo. We enjoy dark humor, sarcasm, funny voices, and wigs. We do not enjoy recorders, and I'm talking about the plastic recorders. Those audio assault weapons will be all melted into the volcano of Mount Doom if I get elected as Queen of the Universe. And for those of you that are new, I do little tags when anyone becomes a member or super chats just as a way to really acknowledge your support. I don't know if you can see it. Let me go to solo. So right in the background by the candle is a shadow box. And once my poster board of, mayhem gets full, I put all of those in there. And that's all just 2024. So I really appreciate all of you guys' support. And Broken Baker for letting me steal his ideas. Let's see here. So the DA wanted to basically disparage this mother. So Rice said, DA Linda Stanley is speaking about Brooke Crawford, a Cannon City mom charged with child abuse resulting in death. Her 10-month-old son, Edward, was left in the care of William Jacobs back in May. Police say Jacobs told the detectives he shook and laid hands on this baby to get him to breathe. This is the DA. I just had so many buzzers going off when they said that the boyfriend was watching him. Rice. While police investigated the case, unfortunately the baby passed at Children's Hospital. That's when DA Stanley's office upgraded Jacob's CA charges to first-degree murder. There's no witness. There's no nothing. There's a whole lot of things indicative of a prior incident with that baby. Prior abuse that Stanley says is the direct result of Jacobs having direct access to a child he didn't care about. She said the pair moved into Motel 6 room together merely days after meeting one another. The DA tells 13 investigates the criminal evidence points to a relationship where the child was not a first priority. Without the caring factor, without the love factor, then a baby's a pain in the ass. The DA says just before the baby was unalived, Jacob had been released from a youth correctional facility. She said that Jacob was previously convicted of an SA crime. Again, these are things that should not be disseminating in the public. These are more prejudicial than probative. And right now, this is where she is nuking an entire case. And I guarantee you, she didn't tell him anything was off record. She wanted to run her mouth. She wanted to be a YouTuber. She wanted to be a true crimer and speculate and throw wild accusations out. And she didn't give a damn about this case. She wanted to look like a badass boss bee that, was taking it out on these predators. But instead, she managed to nuke the case from orbit. I'm going to be very blunt here. He has zero investment in this child. Zero. He was watching that baby so he could get laid. That's it. Have a place to sleep. I'm sorry to be so blunt, but honest to God, that's what's going on. Let me pull a picture of her. She is, not very old. I'd say middle-aged maybe, but let me share this tab instead. So this is the district attorney. Like I said, I have not been involved in the Morphew case. So I have not been at all on the radar of this woman, but she is, let me see. Sometimes they put the age in here. I don't see the age, but she looks, wait. Yeah, she looks to be in middle age. On one hand, I don't think it's good that people can reliably are attacked in prison if they've hurt a child, because that's not the law. But on the other hand, even convicts have a good core. Yeah, I'm kind of okay with Gen Pop Justice allegedly in Minecraft, Raja Mohand, the leader of YouTube right now, and rest in peace, Susan Wiki. These are things that are prejudicial to an entire jury. She should have kept her mouth shut. She is not a baby lawyer. She has been practicing since 2012, I believe, because they go through her CV. This is beyond anything that any DA would ever say. And because of this, again, I don't think you guys, it makes me want to say all the curse words that I can on one breath. But these two people that allegedly could have been responsible for ending this child's life can never be prosecuted for this case because of how much she ran her mouth. And why she isn't run out of town right now, figuratively, and out of a job, I do not know. Because I really could I give very much importance to Suzanne Morphew, but this is the case where I would have, I would make it my job to stand outside her office with a freaking poster and get other people to do it, because this is the one that burns my biscuits to no end. She didn't have to run her mouth. She knew damn full well that anything you say to a reporter can and will be used against you like any normal human. And she decided to run her mouth and, be sassy, just like she had her own name when she went onto YouTube, comments when she was on a YouTube channel and people didn't like her opinion. So she wrote in her own name and, tried to be sassy Miss Sassy Kathy. I mean, the lack of discernment this woman shows. She should never be in charge of anything. She should never be in a leadership position, and she should never, ever be allowed to run her mouth again. Rice, Today, we reached out to Jacob's attorney for a comment on Stanley's view of his motives in this case. We are still awaiting his response. Jacobs will be due back in court later this month. Now, Rice testified that everything the DA said was quoted as coming from the on-the-record conversation. Along with the clip, KRDO ran a written article on its website entitled, quote, Fremont County District Attorney believes accused baby killer got with the baby's mom just to get laid. You said it. They're going to use it. The majority of comments responding to the written article expressed outrage condemning Jacobs and Crawford or calling for swift and harsh penalties. And that's exactly what she wanted. She knew how to shade this. She knew what she wanted. She wanted, pitchforks and torches out. She wanted vigilante justice. She wanted it so when every single juror got into that chair, they could not be unbiased. They would want their pound of flesh. The DA recounted that she learned about the segment from her then ethics lawyer on August 2nd, 2023. She was, quote, horrified by the broadcast. Her statements were, quote, over the top, she said, and she felt shocked and sick to her stomach as though she were going to vomit. Yeah, because you see your career and law license just like that last little turd in the toilet bowl, just going down into that hole. Ma'am, you are sick to your stomach because you are going to look bad. You didn't give a shit about that baby. You were like, oh, I'm going to lose my job. I can't with this woman. And sorry for my cursing. But she testified she was entitled to make each one of the statements off record without running afoul of the rules of professional conduct, that her statements were not likely to heighten the condemnation of Jacobs or Crawford, and that she was somewhat surprised that people were shocked by what she said. The DA said she told her ethics lawyer that she understood her conversation with Rice was off the record, and she authorized her lawyer to contact Rice to convey that understanding. Soon after, she called Marija Souza, the administrator for the 11th Judicial District Attorney's Office. I follow trials, and my one kryptonite word is judicial. Sousa worked for the DA, but they were also friends. According to Sousa, the DA was crying and very upset, displaying stress and emotion, and could not complete a sentence. According to Sousa, the DA was adamant she had talked to Rice off the record. No, you didn't. I barely... But it really is like, who do I think are more douchey professions? This DA or a journalist? But at this time, I'm going to trust the journalist. I'm going to trust the journalist and say that he shaded nothing, you said nothing, and you're trying to cover your ass, but you only have one napkin. So good luck with that. It is a document for her disbarment. But this is all taken from depositions. This was, I believe, a week-long hearing. So they, interviewed the DA, they interviewed all of these people, and this was taken from a deposition. So this is not like they just slapped it together in Chat GPT. Raines, executive director of CDAC, also saw the KRDO news piece. Concerned about the story, he conferred with Dan Rubenstein, the elected district attorney in the 21st Judicial District, then the president of the CDAC. They agreed that the respondent's comments violated her ethical duties regardless of conduct or context, whether on background or off record in which the statements were made. Raines and Rubenstein concluded they had no choice but to notify disciplinary authorities about the comments. They also alerted the respondent that they had reported her conduct. Legal consequences in the Jacob and Crawford cases. Tom Deluxe, alternate defense counsel appointed for Crawford, heard the news story from Jacob's public defender. Deluxe was appalled, shocked, and could not believe what he heard. Immediately, Deluxe thought that the DA's statements met the elements of the doctrine of outrageous government conduct, which centers on whether a governmental actor's conduct violates the fundamental fairness and is shocking to universal sense of fairness. On August 7th, 2023, Deluxe moved to dismiss Crawford's case, arguing that the respondent's comments were, quote, breathtaking in their prejudicial nature, which I agree. Look, I don't like these two people. I wish that they could still be prosecuted. But say I take a person like Sarah Boone, who I deeply dislike. If this is shown to be happening by the state for her, I will fight for her, which will hurt my soul in irreparable ways. But you have to be principled, even when your heart wants to say, you know, Jesus flipped some tables. I'm just saying. We still, if we want this justice system to be what we intended it to be, then we have to play by these rules. We can't let our emotions get into things. And I understand that the DA was probably rightfully, as a mother, as a human, very offended to her very core at the loss of a child because of violence. But that doesn't mean you get to run your mouth. You are a DA. You are supposed to be professional. Leave the running of the mouth to me. I am quite good at it. Welcome, Brenda Little Sis. The DA's comments to Rice were so egregious as to, quote, justify the exercise of the court's supervisory powers in dismissing Crawford's criminal case. Deputy District Attorney Wendy Owens responded to Crawford's motion on the prosecution's behalf on August 10th, 2023. The response did not assert that portions of the DA's interview had been conducted off record. The filing acknowledged, however, the respondent's comments did not reflect her best judgment. The DA neither reviewed nor asked to review the response before Owen filed it. On December 18, 2023, 160 days after the story posted and more than 1 month after the complaint in this case was filed, the DA wrote a letter to Rice requesting that he take the story down. In the letter, the DA upbraided Rice, quote, I repeatedly told you I could not talk about any pending cases. You disregarded that request and broadcasted my statements about the Crawford and Jacobs cases. She requested that he immediately remove the video from all media sources because, quote, he knew it was off record, but also because the video is potentially causing harm to the case. The DA conceded that she did not contact Rice or demand that KRDO retract the story or take it down, nor did she issue a press release about Jacobs and Crawford's presumption of innocence before that point. She did not take those steps, she said, because she did not want to resurrect the news story. She finally sent the letter in December 2023 on advice of her counsel. Welcome, Jariah. Also in December 2023, Judge Thomas Flesher held a hearing on the defense's motion to dismiss in the Crawford case, which had been transferred to Pueblo, probably because he couldn't get a fair trial in the area he was in because she ran her mouth. On April 23, 2024, Judge Fletcher granted Crawford's motion to dismiss for outrageous government conduct, and in the order dismissing Crawford's case, Judge Fletcher observed the contradiction in the DA's decision to invite KRDO into her office and later remarked, quote, I don't like to bring DA business out in public because that's a risky thing to do, end quote. Judge Fletcher's order concluded that the respondent intentionally made statements about a pending case and ruled that those statements, which had no legitimate purpose, violated Crawford's due process rights and notion of fundamental fairness. The order dismissing Crawford's case was stayed for 14 days to allow the prosecution to appeal. On May 7, 2024, Owens filed a notice of appeal, and the appeal is currently pending. Let's see here. At some point after Crawford's preliminary hearing, all of the judges in the 11th Judicial District recused from her case due to the respondent's KRDO interview. The case was then assigned to a 10th Judicial District. So they have taken this case all the way out. Deluxe reported that a different jurist also dismissed Jacobs' case on May 29, 2024. Judge Caitlin Turner found that the respondent knew that she made statements that she was being recorded, as evidenced by her placement of a microphone on her lapel and the visible camera pointed directly at her. Her acknowledgement that she was being recorded when she hit her BS button, and her omission of any direction to Rice that specified comments were off the record. Judge Turner's order concluded that the DA knew, or reasonably should have known, that her comments would be disseminated by means of public communication, and that her comments had the substantial likelihood of materially prejudicing the criminal cases and heightening public condemnation of Jacobs, and that the comments reflected knowing and intentional outrageous government conduct that violated Jacobs' rights to due process. Now, let me see if I can actually pull up the article that talks about this. I don't want to be in. Okay, let me see if I can share this tab. So these are some of the local news stories that came out on June 1st. Charges against Colorado couple accused of unaliving baby dismissed because of district attorney's comments. So this is from CBS News Colorado. A Colorado couple charged in the death of a 10-month-old had the charges against them dismissed because of comments that Fremont County District Attorney Linda Stanley made to a news station in Colorado Springs. A judge found Stanley violated the couple's rights after she gave an interview to KRDO TV in 2023, where she made inflammatory statements about William Jacobs. Sorry, I want to rename you, but you both have high eyes and do better, both of you. You have been given a get out of flippin' jail free card. I don't think you should have, but do better with your life. For God's sake, do better. You have the death of a 10-month-old on your soul. You might want to work on that karma, both of you. Ugh. Stanley told the news station about Jacobs, quote, "I'm going to be very blunt here. He had zero investment in this child. Zero. He was watching so that he could get laid. That's it. And have a place to sleep. I'm sorry to be that blunt, but honest to God, that's what's going on." About the couple's attitude toward the baby, Stanley said, "Without the caring factor, without the love factor, the baby is a pain in the ass." About Brooke Crawford, Stanley said, "She's got a live-in now. She doesn't have to worry about anything." CBS News Colorado legal analyst and former district attorney Karen Steinhauser says that when it comes to talking to the media, all lawyers, but especially district attorneys, need to be careful what they say. Quote, "All the rules are designed to make sure that people get a fair trial," said Steinhauser. "There are certain ethical obligations that a prosecutor has, and so much of that has to do with making sure that everyone involved in a criminal justice system has the right to a fair trial, and that justice is served," end quote. So this is, Miss Stanley right here in all her glory. Now all charges against Crawford and Jacobs have been dismissed because a judge found that those statements tainted the jury pool in Fremont County. Steinhauser says that when something like this happens, the whole community pays the price. Quote, "The number one thing that a prosecutor is elected to do is justice. When they are alleged to do things that interfere with justice being served, interfere with our defendants' right to have a fair trial, all those things affect not just defendants, but the victims," said Steinhauser. According to county records show that Jacobs was initially charged with, all the badness. This isn't the first time that Stanley has gotten in trouble for statements she made to the media. In 2023, she made statements about the Suzanne Morphew case to true crime show host, while also failing to disclose critical evidence to the defense in the case. For that and these new accusations, she is facing a disciplinary hearing that is set to start on June 10th. So from the articles that I read, one of them said it was dismissed with prejudice. So let me look at all the articles, or let me look that up real quick. But I believe it was dismissed with prejudice, which means they can never bring it back. Okay. No, I don't want to. I don't want to log in. No. Damn you. Sorry, I'm trying to read through because I know one of these had that it was dismissed. Okay, here's the motion. Order granting motion to dismiss for outrageous government conduct. I know it's not huge. Let me see if I can. No. You guys know me. I'm not tech. Okay, let's see here. This matter comes before the court on Mr. Jacobs' motion to dismiss for outrageous government conduct based on the actions of elected district attorney Linda Stanley. The people opposed the dismissal of charges. The court held hearings on the motion on February 1st, 2024 and March 22nd, 2024. The defendant was present and represented by attorneys Jake Toffer and Daniel Zelter. The people were represented by Deputy District Attorney Wendy Owens. The court notes that there is a co-defendant charged in this matter, Ms. Brooke Crawford, and the case is before the Honorable Thomas Flesher, who was assigned by the state court administrator when Chief Judge Patrick Murphy entered an order recusing all judges in the 11th Judicial District from presiding over this case. The court takes judicial notice of Judge Fletcher's order granting Ms. Crawford's motion to dismiss charges against her based on District Attorney Linda Stanley's outrageous government conduct. The order is pending review before the Colorado Court of Appeals. This court has heard statements and arguments from counsel and has reviewed voluminous exhibits and including video recordings of elected District Attorney Linda Stanley making statements about this case and the co-defendant's case to KRDO television reporter Sean Rice. The court has had the opportunity to review the defendant's initial motion for dismissal due to outrageous government conduct filed on December 15th, 2023. The people's response to the motion to dismiss filed on January 5th, 2024. The defendant's reply to the motion filed on January 31st, 2024. The people's additional response to the motion to dismiss filed on February 1st. The defendant's supplemental motion to dismiss filed on March 15th. The people's response to the supplemental motion to dismiss filed on March 20th, 2024. The court, having considered the statements and arguments of counsel, the written motion and responses, and the exhibits filed, and being fully advised in this matter, finds and orders the following. Background. The people charged Mr. Jacobs with first-degree murder and other offenses related to the death of a beautiful baby boy. The prosecution's theory is that while Mr. Jacobs was alone with the baby on the morning of May 21st, 2023, Mr. Jacobs laid hands on this baby, for which he ultimately died. At July 12th, 2023, setting conference, Magistrate Court scheduled a preliminary hearing for Mr. Jacobs. DA Linda Stanley appeared on behalf of the people in person at this setting conference. That is the only time that DA Stanley appeared in this case. KRDO reporter Sean Rice and his cameraman attended this setting conference and approached DA Stanley following the hearing to request an interview. Thor, get your fluffy behind off the computer stand. Let's see here. DA Stanley agreed to be interviewed right after the setting conference, and Mr. Rice and the cameraman were escorted to DA's office inside Fremont County Courthouse. Portions of this interview were first aired on the news station KRDO that same day, July 12th. If you can hear this, this is a cuddle whore who has a deep and abiding love for my monitor. No, we've talked about this. You guys do not go on the desk. That is not the rule. We've talked about this. Well, at least he's trying not to land on my tower today because, that has happened. He knows I'm wearing black. He's like, oh no, we are going to cover you with Thor fur. So you look like you have a fine fuzz on you. Let's see here. On the same day, Defendants Exhibit D, embattled 11th JD A DA addresses allegations that she contributed to case dismissal and freed PDF files, if you will. Published 7/12/2023, last visited May 29th, 2024. Parts of the interview are related to Mr. Jacobs and co-defendant Brooke Crawford. First aired on August 1st, 2023, KRDO News. Fremont County District Attorney believes accused baby unaliver got away with it got with mom just to get laid. Published 8/1/2023, last visited May 29th, 2024. A preliminary hearing before this magistrate court took place over several days in October and November of 2023. The magistrate found probable cause for 3 felony counts and bound the case up in this court's division. The defendant alleges DA Stanley's recorded statements to KRDO reporter Sean Rice amount to outrageous government conduct and warrant dismissal. The people opposed dismissal of the charges and argue that while elected district attorney's statements certainly do not reflect her best judgment, they do not rise to the level of outrageous government conduct. Applicable law. Colorado recognizes due process claim of outrageous government conduct. Bailey versus People, quote, outrageous government conduct is conduct that violates fundamental fairness and is shocking to universal senses of justice. When outrageous governmental conduct occurs, dismissal of the charges is warranted. People versus Allude, upholding the dismissal charges based on a finding of outrageous government conduct. Trial courts determine whether outrageous government conduct has occurred by, quote, reviewing the totality of facts given in the case. You know, I'm thinking I'm going to put a little GoPro on Dingus to see what he does all day. I will tell you that he nearly killed me yesterday because he loves as the laundry tumbles. So we have a front-loading washer, which I hate because they grow mold if you the salesperson always says, well, just leave the door open. I'm like, I don't think you understand. We have 8 people in this house and no one can use a towel more than once, no matter how many times I've asked. So it is a constant battle with that, but I think Dingus would revolt if we got rid of it because he loves watching the laundry just swirl around. Let's see. And that is People versus McDowell. Quote, the question whether circumstances are demonstrated which would bar prosecution under due process principles is for the court. People in Tension of Missouri, I believe. A trial court has discretion to dismiss when ruling on the issue of outrageous government conduct. So basically, she has the power. Like Daryl Brooks, she has the power to dismiss this damn case. And even though she doesn't want to go by the letter of the law to give everyone fairness, she's going to have to. Factual findings. In the spring and early summer of 2023, DA Stanley and her office faced media scrutiny after the courts imposed severe discovery sanctions based on the DA office's years-long pattern of discovery violation. See People versus Tippett. Quote, detailing the 11th Judicial District Attorney's Office pattern of practice of discovery violations and affirming the district court's reduction of a first-degree murder charge. News coverage of the discovery violations and other alleged problems within DA Stanley's office received widespread media coverage throughout Colorado. Exhibit A from the defense, quote, this is an article, Colorado judge sanctions Fremont County District Attorney Linda Stanley for repeatedly violating court procedures. Exhibit B, Fox 21 exclusive, 11th Judicial DA breaks her silence to address allegations of misconduct. So these were published on 7/11/2023, last visited May 29th, 2024. Exhibit D, embattled 11th JDDA addresses allegations she contributed to 2 case dismissals and freed sexual predators. Exhibit F, District Attorney Linda Stanley speaks out. In the 6 months before July 12th, 2023, KRDO reporter Sean Rice had repeatedly reached out to DA Stanley for a comment on stories his news channel had reported about her office and had not received a response from her. These all have exhibits of him trying to get a interview with her. Reporter Rice and photojournalist Peter Miller approached DA Stanley right after a hearing in Mr. Jacobs' case on July 12, 2023, and she invited them to her office for an interview. The interview began with an off-record conversation that lasted about an hour. DA Stanley next engaged in a recorded on-the-record conversation for about 30 minutes. Yeah, that's what I don't get. So if you absolutely say, like, this is off the record for an hour, you would think you would only talk about on-the-record things this morning. But, who knows? During the recorded part of the conversation, DA Stanley commented on Mr. Jacobs' case, co-defendant Brooke Crawford's case, and another unrelated case, the death of Suzanne Morphew. The on-the-record portion of the conversation began with DA Stanley providing information about Mr. Jacobs' juvenile criminal record. She told reporter Rice, quote, "He has a pretty awful past, include fondling his mom. It's not good. It's kind of weird. What kind of kid fondles their mom?" She shouldn't be telling him any of this. Those are generally sealed. DA Stanley acknowledged that she was aware of public discussion about Mr. Jacobs' case, saying, quote, "I agree with the general public from what I understand on social media when they're talking about how could a mom, have done all this. Well, quite frankly, I think she saw a live-in babysitter. Now she can really just pound out the hours. She's got a live-in babysitter now. She doesn't have to worry about anything." Stanley's on-the-record comments included, 1, she felt so strongly about the Jacobs case she decided to be the lead prosecutor. 2, she stands by her decision made in the days after the death was pronounced to upgrade charges against Jacobs from child, badness, CA, resulting in death, to first-degree murder. 3, the death was completely avoidable. 4, Mr. Jacobs had access to a child he did not care about. 5, Mr. Jacobs moved in with Miss Crawford just days after meeting her. 6, Mr. Jacobs had recently been released from a youth correctional facility. 7, Mr. Jacobs was previously convicted of a sex crime. 8, Mr. Jacobs had a violent past. 9, Mr. Jacobs was a flight risk and quote-unquote would be gone if he was not immediately arrested. At no time during the on-record conversation did DA Stanley state that the charges against Mr. Jacobs were merely accusations or that Mr. Jacobs is presumed innocent until or unless he is proven guilty. DA Stanley's on-the-record statements broadcast repeatedly by KRDO included all the things that I've already told you, he was just there to get laid, I had so many buzzers going off, that I'm going to do this myself, all the girl boss, kind of stuff she wanted to say. DA Stanley knew when she made these statements she was being recorded. For one, DDA Owens conceded during the March 22, 2024 hearing that DA Stanley knew she was being recorded during the 29-minute segment of her interview with reporter Rice. In addition, reporter Rice testified under oath the following. 1, DA Stanley herself placed the live microphone on her lapel when the recorded part of their interview began. 2, the video camera used was visible and pointed directly at DA Stanley. 3, prior to donning the microphone, DA Stanley had not asked the reporter Rice to refrain from broadcasting recorded portions of the interview. 4, at no time during the interview did DA Stanley ever change her mind and convey that she wanted the statement to be off the record or on background. Let's see here. Finally, DA Stanley herself revealed that she knew she was being recorded during the interview when she told reporter Rice, quote, "I really want to hit my button right here, or right now, but I know I can't do it since we're recording." Despite acknowledging that she knew she was being recorded, moments later, DA Stanley hit her button and it emitted this phrase, quote, "If bullshit were money, you'd be a millionaire." This woman is a cartoon. District Attorney Stanley made pre-trial extrajudicial on-the-record comments to reporter Rice. These comments were made public in writing, online, and in newspapers, and were broadcasted on television news and the radio. Improper extrajudicial statements taint the jury pool and deprive individuals of a right to a fair trial. U.S. Constitution Amendments 5, 6, and 14. I'm like, what is Roman numeral for whatever that is? Colorado Rules of Professional Conduct, Rule 3.6 and 3.8, provide a framework regarding making extrajudicial statements. So we've kind of been over. Rice is a man. So we've kind of been over this, but basically the rules say that you aren't allowed to say anything that would prejudice the trial. Let's see, Rule 3.8F, which refers to the special responsibilities as a prosecutor, provides that the prosecutor in a criminal case shall, quote, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and serve legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused unless such comments are permitted under Rule 3.6b or 3.6c or other law, or exercise reasonable care to prevent investigators, law enforcement personnel, employees, and other persons assisting or associated with the prosecutor in a criminal case from making extrajudicial statements that a prosecutor would be prohibited from making under Rule 3.6 or this rule. As cited in Mr. Jacobs' motion, the American Bar Association Standards for Criminal Justice, Fair Trial, and Public Discourse Standards 8.2 subsection A provides, subject to any additional limitations imposed by local or professional rules, during the pendency of a criminal matter, a lawyer participating in that criminal matter should not make, cause to be made, condone, or authorize the making of public extrajudicial statements if the lawyer knows or reasonably should know that it will have a substantial likelihood of influencing the outcome of that or any related criminal or trial or prejudicing a jury. So basically they're saying, don't freaking do this. For the love of all that is holy, don't be a dumbass. The comment section following Colorado RPC 3.6, specifically comment 5, subparagraphs 1, 4, 5, and 6. This is why I couldn't be a lawyer. For every rule, there's a subsection of a substack of a, interdictionary, freaking, they've got like friggin' subsections out the yin yang. I could not deal with that. Let's see. Describe certain subjects that are more likely than not to have material prejudicial effect on a proceeding. And these subjects include the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness. Any opinion as to the guilt or innocence of a defendant or suspect in a criminal case. Information that the lawyer knows or reasonably should know is likely to be inadmissible as evidence in trial that would, if disclosed, create a substantial risk of prejudicing an impartial trial, and the fact that the defendant has been charged with a crime unless included therein is a statement explaining that the charge is merely an accusation and the defendant is presumed innocent until or unless proven guilty. Another relevant factor in determining prejudice in this nature is of the proceeding involved. Criminal jury trials will be the most sensitive to extrajudicial speech. The people argue that whether DA Stanley's pretrial extrajudicial statements would be admissible at trial or would constitute prosecutorial misconduct is, quote, completely irrelevant to this court's determination of the motion for outrageous government conduct. The court recognizes that the preamble of the Colorado Rules of Professional Conduct provides, quote, violation of a rule should not in and of itself give rise to action, nor should it create the presumption that legal duty has been breached. Yet, ethical standards for prosecutors may provide a framework for determining whether the rights of the defendant have been violated by prosecutorial misconduct. All lawyers are presumed to know the rules of professional conduct. DA Stanley knew or reasonably should have known that her on-the-record comments to reporter Rice about Mr. Jacob and co-defendant Ms. Crawford would be disseminated by means of public communication, and that they would have a substantial likelihood of material prejudicing these criminal proceedings. First, DA Stanley's comments were made while 1. Talking to a reporter, 2. Wearing a microphone, and 3. With a camera pointed directly at her. 4. Which camera was operated by a cameraman. Secondly, she is bringing all the snark. She's like, "You are dumb, and I am going to tell you about it." Second, DA Stanley's comments were imbued with substantial likelihood of heightening public condemnation of Mr. Jacobs. Her comments included her vesperative, sensational, and inflammatory opinions of Mr. Jacobs' character, his credibility, his reputation, and his criminal record. Third, DA Stanley had to notice that improper pretrial extrajudicial statements would have a substantial likelihood of materially prejudicing the defendant's right to a fair trial. In another high-profile first-degree murder case, the People versus Morphew, Chaffee County District Court, DA Stanley made pretrial extrajudicial statements, including 1. Stating during a press conference that Mr. Morphew had invoked his privilege against self-incrimination and had refused to talk to the police after being arrested. 2. Repeatedly made statements about the case on true crime YouTube broadcast shows like Profiling Evil and True Crime with Jules. 3. Commenting about the pending case to hosts of these broadcasts through text messages and Facebook Messenger. 4. Using her own name as her username, posting about the pending case and responding to critics of her office in written comments sections of these broadcasts. DA Stanley's pretrial extrajudicial statements, Judge Lama made findings in January 31, 2022, that DA Stanley had violated the court's pretrial publicity order, and her statements had materially prejudiced Mr. Morphew's right to a fair and impartial jury. Lastly, during the on-the-record conversation, DA Stanley demonstrated that she had actual knowledge of pitfalls of DAs speaking to the media about a pending case. DA Stanley stated, quote, "I don't like to bring DA business out in the public because it's a risky thing to do. I can't talk about an open case. I'm forbidden from it. Defense can do it all day long." No, they can't. There are gag orders on the defense, this crazy ass heifer. I can't say a word about an open case, and yet you did. Like the court in Miss Crawford's case, this court cannot find that there is any legitimate reason for District Attorney Stanley to make the statements she made to reporter Rice, and thus the court infers and finds that those statements were made to be specifically prejudice Mr. Jacobs and co-defendant Brooke Crawford. To the extent that any statements were more specific to Miss Crawford, they implicate and impact Mr. Jacobs. DA Stanley's comments undermine the public's respect for judicial process. Because there is no legitimate purpose for making these statements, the court finds the district attorney's actions to be shocking to the universal sense of justice and the standards and presumptions on which our judicial system is based. The People suggest that the appropriate remedy for any presumed prejudice caused by DA Stanley's pretrial statements is a change of venue. The court rejects this suggestion. The accused has a right to a public trial by an impartial jury in the county or district in which the offense is alleged to have been committed. Colorado Constitution, Article 2, subsection 16. The requirement that the trial be held in the county or district of the offense is solely for the benefit of the defendant, Davis versus People. Mr. Jacob has not requested a change of venue. Rather, Mr. Jacob asserts that his right to a trial to a jury of his peers includes a right to a trial in his community, here in Fremont County. The court acknowledges its inherent power to change venue on its own motion if such an action is necessary to provide the defendant a fair trial. Wi-Fi page, I don't know, something judicial. Whether to change the place of a trial is a question determined by the court on its sound discretion. Court notes that it can find no reported Colorado cases construing a right for the prosecution to request a change of venue. Here, the court determines that exercising its discretion to change venue over the objection of the defendant would not serve the interests of justice. Were the court to order a change of venue over the defendant's objection, the court would in effect condone improper pretrial extrajudicial statements by the prosecutor. A prosecutor should not perceive license to make public comments, heightening public condemnation of an accused, only to then turn around and suggest a change of venue can excuse such prejudicial conduct. Finally, the people assert that even if sanctions were appropriate, dismissal is too severe a sanction. The people suggest that disciplinary sanction sought by the Office of the Attorney of Regulation Counsel in People versus Stanley would potentially serve as a deterrent sanction for DA Stanley's prejudicial statements. As discussed during the motions hearing, the people failed to persuade the court on this basis. The outcome of that disciplinary proceeding is yet to be determined, and any sanctions potentially imposed by the presiding disciplinary judge would not help cure the prejudice suffered by Mr. Jacobs. Even if DA Stanley were ultimately sanctioned for her alleged failures to comply with the Colorado rules of professional conduct, those proceedings were not adequately remedied to restore Mr. Jacobs' right to due process. Having reviewed the totality of facts, this court concludes that DA Stanley's actions reflected knowing and intentional outrageous government conduct. This conduct violated Mr. Jacobs' right to due process. As a result, the dismissal of these charges is an appropriate remedy. The court therefore orders dismissal of the charges against the defendant, William Jacobs. So it doesn't say with or without prejudice, but I did read somewhere that it was with prejudice. I'm hoping that it's without and they can bring it back, possibly. I don't know if a future DA that's going to be put in her place would do that, but I think that this is a case that definitely needs justice served. Again, as a DA, you are supposed to be representing us, the people. You are supposed to be the voice for that little boy. This is not supposed to be about you. It's not supposed to be about whether you think these people are garbage humans. That's my job. I'm allowed to run my mouth. I'm a unicorn on the internet. I have fun hair and I wear fun clothes, and I'm a great success. This is the portion of the case about the death of a little boy that she so thoroughly screwed up that both cases against the parents or the boyfriend and the mother have been dismissed. I am trying to find out if it was dismissed with prejudice or without. I do believe it was with prejudice. And she also was the DA when the Fremont County District Attorney Office was covering the Suzanne Morphew case. Like I've told everyone, I was not really into the Suzanne Morphew case. I don't know what I was doing, but I wasn't paying attention. Generally, if a case gets big traction and starts getting really big sides and really kind of, I stay away from those cases. I don't like drama. I don't want my house swatted because I have a bad opinion. I don't want people, coming after me, doxing me and all that other stuff, because people be crazy on the internet. You don't think I'm telling you the truth? Go look at any Karen Reed forum, okay? Mostly the Karen Reed is guilty side, but those people are cray-cray, okay? And even the Hales and the Lynette thing, I mean, you have people doxing people, you have people swatting people. It's for damn ridiculous. But this is a case that I think would be a good one to kind of do an overview with fresh eyes. So I will be, after I finish covering this disciplinary disbarment, I will be going through the case kind of contemporaneously. So when she started going missing, the documents that we can pull from that, things like that. I'm also doing the Wade Wilson case, and as a little bit of housekeeping, tonight we will not be doing nightly newsy news. we will be doing another Very Sarah hearing. You know, if the state could prove it, they could, but they didn't seem to be able to prove it in this last one. It looks like they do have a new district attorney, so I will be upset if we don't get what if anythings. But I am going to go ahead and get hop off here because I am going to, well, glamorously go mop floors. I did talk to Mr. Mo about getting like a fleet of Roombas, but I haven't. I will tell you that I watched most of the Karen Reed case and they didn't prove it to me, but I'm willing to hear evidence that she did. I'm willing to relook at the case. Like I said, people just get absolutely nuts about these cases. And I don't want to be like other true crimers, lay tubers, whatever I am. I don't want to be one of those people that hands out wild speculations, which is why I kind of go through court documents and things like that. I think there are things that separate. They don't know it's his hair. Great success. They did mitochondrial DNA. It could have been his hair. It could have been the nieces and nephews' hair. Mitochondrial DNA only says that you have the same maternal link. It did not have the bulb on it. So I will say, there are strong opinions on every side. And what I really like about watching trials, watching all of LawTube, is that people can have different opinions. And, I can see different perspectives. I like that. It is a superpower and a super burden because I love that I can sort of see all sides, which makes making a decision very, very hard if you can argue on all sides. But I do like people, and you know what? Come in here, have a different opinion, just be, cordial, don't be a jerk face, and we can have different opinions. I love that. Now, I will say, so I told you guys about the Sarah Boone special tonight. I will be putting up a thumbnail. I just saw that she had a hearing today. Way to go, handy dandy calendar, wherever you are. Look, Mo is in the process of trying to get really organized and be semi-professional-ish. I am not there yet. But I'm working on it. And somewhere is a calendar that said that Karen Reed was today. Or not Karen Reed, doggone it, Sarah Boone. But we will be having, instead of Nightly Newsy News, again, we will be having a Sarah Boone, motion. Oh, it was to pay attorneys? Well, damn. We might just look at it a little bit. Thank you so much. I am trying to look like a human. Some days you feel like you look okay. Some days, yesterday I didn't wear any makeup at all. Again, this whole being a girl thing requires a lot of work, and some days I'm just not into it. But I know I told you guys about Bloom Chick, so while I'm off on a tangent, this is a new dress I got from them, and it has pockets. Here, let me see if I can, but it's part of their Halloween collection. It's very cute, comfy, and it has pockets, so I love it. And it's all about the moon, which is, I love Sailor Moon. But I will be back at 6 o'clock tonight for a Sarah Boone hearing. It might be long, it might be short. I might have an emotional support beverage because it's Sarah and her whiny attorney. But I will see you guys there. Thank you for joining me. I know this was a bit of a rough reading just for me and maybe all of you. It is so heartbreaking to realize that this poor tiny baby boy will not get the justice maybe that he deserves in this world, until or unless maybe they can bring the case again. And even then, it really is, very upsetting that this child's life, unfortunately, cannot be avenged. We cannot, get justice, get these people out of the general population. And it is heartbreaking. But good triumphs. This woman is getting disbarred. I mean, that rarely happens, and I am here for it. So I will see you guys this evening. Have a wonderful day, and be kind to yourself, be kind to others, and just be kind. For the love of Cheetos, be kind. Have a good day, guys. Bye.